Hello, everybody, and thank you for joining us from wherever you are in the world. My name is Tom Randall. I'm an editor at Cambridge University Press. And I'm delighted to welcome you all to today's event, launching Dr. Yuri Van Logchim's recently published book, The Rights and Obligations of States in Disputed Maritime Areas. Yuri's book offers a comprehensive overview of this essential and relevant area of international law. And we're very pleased to have a distinguished panel joining us today to discuss the book and its key contributions with him. If you're not already familiar with the book, we do have a 20% discount, which is available for those of you attending today, and this will run until the end of August. I'll leave the details in the chat box so you can look that up on the website, and please do get a copy if you haven't already done so. Whether you've read the book already or just interested to learn more, we very much hope you'll enjoy today's discussion and we'll contribute to the Q&A at the end of the event. So without any further ado, I'll now hand over to Sir Michael Wood, the chair for today's symposium, to introduce the speakers and open up the discussion. Thank you very much.
Well, thank you very much, Tom. Of course, we're here to discuss the content of Yuri's new book, but I want to begin, Tom, by thanking CUP for producing such a handsome book. It really is a pleasure to read. It's convenient, it's clear, and the cover both looks and feels very good. So thank you to CUP. I think you do a tremendous job for international law. I'm not going to say much by way of introduction because I want to hear from the panelists first. But I just say this, that I think Yuri's book deals in depth with what is a very practical area of international law. It discusses the law, both treaty law and customary law, but it also discusses many actual cases, both state practice and the case law. And it deals seriously with the sources of international law. I only wish it had been available when I was dealing with some of the cases that are referred to in the book. Without more ado, and before I introduce the speakers, I'll just ask Yuri if he wants to say a word or two.
Thank you very much, Michael, and also to Tom for the kind introduction. Well, just very briefly, I don't want to go into the content because I rather hear views from the members on our very esteemed panel. But just for me personally, and the journey towards this book essentially began, I think now almost a decade ago, when I was a PhD student at the Netherlands Institute for Law of the Sea at Utrecht University. And well, my thanks is particularly owed to Professor Fred Soons and Alex Oud-Elfring for being my supervisors at the time, and who essentially introduced me to the topic. And the book has essentially been a culmination of that research, which I mentioned spanned more or less a decade. I also want to thank today's panelists for taking the time to actually read my book and discuss the topic of the book, which I think is very topical. So my thanks very much goes to Robin, Natalie, who is actually on holiday and in Australia, for actually being here today, and Bob Backman, who's also not in the most kind time zone for this webinar. So without further ado, I really am looking forward to hearing the panelists' view on the topic and the book, and also thanks to the audience for joining in such great numbers and the interest in the topic and the book. So thank you, and I will hand over the floor back to Michael.
Well, we had a bit of a problem with echo there, but I don't know if other people had it. Anyway, I found a way of stopping it, I think. Well, it's a very distinguished panel, as Tom already said, all experts in this field. And I think that in itself reflects the quality of both the book and the author. Each of the speakers will speak for 15 to 20 minutes. We should then have about 30 minutes for questions and answers. And if you could put questions into the Q&A box, we will monitor that and take as many of them as we can. And we aim to finish at 2 p.m. UK time. So I'll just introduce briefly the three speakers, though they're all well known to you, I'm sure. The first speaker is Professor Robert Beckman, Bob, from Singapore. I say from Singapore because he's associated with so many different institutions there, though I should at least mention the National University of Singapore and the Center for International Law. He will be speaking about maritime disputes in the South China Sea, easily done in 15 to 20 minutes, I think, and about overlapping territorial claims as well, territorial sea claims. Perhaps he might add a word about overlapping contiguous zone claims, which is a subject of particular interest to me at the moment. Bob will be followed by Professor Robin Churchill from the University of Dundee. And before that, from not so far from here in Swansea at the University of Cardiff. Robin, we're all looking forward to the imminent and long-awaited publication of the 4th edition of your book with Vaughan Lowe on the law of the sea. Robin is going to address the obligations of states in disputed EEZ and continental shelf areas. And then last but not certainly not least, Professor Natalie Klein is our third speaker. She's at the University of New South Wales, has written a great deal on all these matters, and will be speaking about the permissible responses that a coastal state may take in response to alleged transgressions against its rights. So without more ado, I'll invite Professor Beckman, invite Bob to say a few words. Bob, you have the floor.
Thank you very much, Michael, and congratulations to Yuri. I hope the sound is okay. I'd like to first make the general comment to congratulate Yuri on the publication of this book, which I've been waiting for quite a while. And I think it's a very well done piece, and we will definitely be recommending it to the participants when we do our annual workshops on maritime boundary delimitation, because the analysis of all the cases and the provisions, I think legal advisors from, as well as academics, will find it of enormous use. I'm going to share a screen if I can. I hope this works as it should. Please let me know if it does not.
That's working, I think. Thank you.
You see the full screen now? I'm going to talk about two areas. I assume my colleagues would be talking about Articles 74 and 83, which is the guts of what Yuri is analyzing. So I'm veering off from those two subjects and doing two other things. First, going to look at disputed territorial sea areas, and then an area that is of great interest in my region, and that's how these principles may apply to the disputed maritime areas in the South China Sea. First, with respect to the disputed territorial sea areas. It's a very interesting discussion on the history of Article 15 of UNCLOS and on the predecessor position in the 1958 convention in Yuri's book. The main focus, of course, is on the Third UN Conference and the provisions on overlapping claims of the economic zone or continental shelf, Articles 74 and 83. But the discussion on the median line as an interim rule for Article 15 for overlapping territorial sea claims seems to assume, and I think in fairness, the ILC also assumed this at the conference, second conference, that states can easily agree on the construction of a median line or an equidistance line. And the argument is you can't go beyond that if there's an overlapping area. But my look at reading of cases, and I think Michael could probably agree, is the state practice in case law suggests that the identification of base points for constructing a median line or equidistance line can be very subjective. and especially if states are employing state baselines or straight baselines or using other offshore features. And therefore, I think the assumption of that rule is that both states could agree we won't go beyond the median line is a rather controversial or a questionable proposition. Uri's discussion of the absence of an interim rule on delimitation is very interesting. I would urge you people that have territorial sea boundary issues to look at it. And unlike the provisions on Article 74 on economic zone and 83 on continental shelf, there's nothing in the overlapping claims of territorial sea. There's no obligations for states to make every effort to enter into provisional measures of a practical nature. And there's no obligation that during the transitional period before the boundary is agreed, they should not take action which would jeopardize or hamper the reaching of a final agreement. Those provisions at the conference were left only in the delimitation of the economic zone and continental shelf. And that makes the territorial sea boundaries quite interesting. My personal thoughts on Article 15, my observations of state conduct in my region of the world, it's because states have sovereignty in their territorial sea. Not just sovereign rights and jurisdiction to resources, but sovereignty, subject, of course, to the passage rights in parts 3 and 4 of the convention. It's often more difficult to reach agreement on territorial sea boundaries than on economic zone or continental shelf, because there's a fear that you're actually giving up your sovereignty or part of your sovereignty. Also, states, at least in this region, seem less inclined to attempt to negotiate provisional arrangements for the overlapping territorial sea claims pending agreement, because there's no language in Article 15 calling for such arrangements, and no language in Article 15 saying such arrangements would be without prejudice to the final boundary agreement. And I think that's quite important. My own observation, sometimes talking to government legal advisors in Southeast Asia, is that when they do agree to provisional arrangements, for example, two states might agree in an overlapping territorial sea area that they can both exercise jurisdiction over fishermen from third-party states, and whoever gets them can arrest them and the other won't complain. But there's never a formal treaty agreement that says that. What the government people will say, well, we have informal arrangements at an operational level, and therefore we cooperate on ships that may be intentionally polluted in the overlapping or undefined area, or vessels that may be engaged in other illegal activity. And I think, again, part of that is because territorial sea is subject to sovereignty. So that's quite an interesting, I think Uri's analysis of this is certainly worth the careful study. But I'll give you a couple more comments on this. Last year when we had a boundaries workshop at NUS, I was searching with colleagues around the world trying to find examples of provisional arrangements on overlapping territorial sea claims. And I came up with almost zero that people said, well, we have examples on economic zone continental shelf, and we couldn't come up with any written. We found a couple provisions in agreements, et cetera, but they're not very likely. I guess my final point before I go to my second one is overlapping contiguous zones. Maybe you should talk to Thomas Hyder on this, because in week 2 of the Rhodes Academy, a common question often was, what happens when there's an overlapping contiguous zone? Overlapping claims to a contiguous zone. There's obviously no provision in UNCLOS relating to the delimitation of overlapping contiguous zone. The assumption I've always had is because states simply have special rights to enforce their customs and so the CFIS, customs, fiscal, immigration, sanitation laws, that it wouldn't make any difference that it overlapped. If there's an overlapping area for adjacent states, states A and B are adjacent, maybe the overlapping or opposite, either state can enforce those laws if the state violates the territorial sea and then enters the contiguous zone of the other. But certainly I've never seen any description as to why the at the third conference there was, or second, or first and second, there was never any discussion of overlapping areas or the delimitation of contiguous zones. But that's about the best I can do, Michael, on short notice. I'd now like to talk about issue that continues to be take a lot of our time for the observers on the events in the South China Sea, and that's the disputed maritime areas in the South China Sea. I start with an analysis or some of the language in the book by Yuri, in which he talks about the crux of the matter on overlapping claims. Crux of the matter pending delimitation lies in the fact that there are concurrent claims to sovereignty or sovereign rights of coastal state in relation to the same disputed maritime areas. And the general thesis is that equal weight has to be attributed to states' entitlements and related rights. That is, as long as the International Court or Tribunal has not pronounced on the respective strengths, assuming the claims to the states to maritime areas are not excessive, not sure what that means, meaning that these claims at a minimum rest on prima facie basis of international law. Therefore, the conclusion was the general crux is the state cannot claim to have a superior entitlement vis-a-vis the other claimant state. That's the crux of it. That I think Yuri's comments in his book on the South China Sea, which I admit is a very, very small part, and I think it was completed. I know how long these books take. I think his analysis of the South China Sea in the book was done before the 2016 arbitral award was announced, and therefore I certainly would not fault him for analyzing it the way he did. But what I'm going to try to do is bring it up to date a little bit. But again, in a general book of this, in which you're talking primarily about Articles 74 and 83, it's not possible to expect anyone to go into the detail on the complex disputed areas like the South China Sea. The issue is how the analysis applies in a situation where the maritime claims of one of the parties may not be consistent with either the law of the sea convention or customary international law. And that is the result, for example, of the arbitral award. But so the analysis that he had now makes in the book, or has made in the book in section 7.2.19, seems to assume that equal weight must have been given to attribute to maritime claims between all of the states surrounding the South China Sea. And of course, this equal weight does not take into account the 2016 award. For those from outside, from European benefits, the South China Sea borders to the north China. That's the island of Hainan, if you can see my cursor. Going down to the west, it's to the country of Vietnam. Then it goes down to the Tuna Islands that are not in dispute, and their sovereignty is under Indonesia, which is not disputed. Then East Malaysia and Brunei over on the island, and then the Philippines up here. So you have ASEAN member states, you have Malaysia, Brunei, Malaysia, Philippines, and Vietnam. Indonesia is not a claimant state because it doesn't claim any of the disputed islands. but it has overlapping maritime areas with China. The crux of the disputed areas are disputed maritime features. That's not, and the question, of course, would be the disputed features. This map shows you some of the complexity that I think this is as of 2010, if I recall correct. Those features in green are occupied by the Philippines. Those in red are occupied by China. Those in purple are occupied by Vietnam. There's one dark blue or black one in the middle, Ituaba, which is occupied by Taiwan. And down to the south is those in yellow are occupied by Malaysia. Now, all of these islands, as far as we know, are claimed by China, sovereignty over them. Most are claimed within this octagon that you see, part of the octagon circle. All of those within that octagon-shaped area are claimed by Philippines. All of them are claimed by China and Vietnam, and we're not quite sure how many of them are claimed by either Malaysia or Brunei. But many of them are fortified, so this is the heart of the dispute in the South China Sea. The other area to the north, the Paracel Islands, are occupied by China, but also claimed by Vietnam. One of the issues there, of course, is the legality of the Strait baselines, because it's a mid-ocean archipelago and Paracels are not an archipelagic state. There is a boundary between the Gulf of Tonkin between Vietnam and China up to this point. They're negotiating this dotted line area, and there's discussions of whether there should be an equidistance line or whether there should be a joint development area, and there's no agreement. Part of China's 9-dash line comes here. That's the red line to the left of the screen is the territorial sea boundary of, or it's the baseline, I guess, of Vietnam, and the territorial seas beyond that. Now, until 2009, it was not clear whether the ASEAN countries that surrounding the South China Sea were claiming an economic zone continental shelf from the islands over which they claimed sovereignty, or the islands over which they occupied and claimed sovereignty. We simply didn't know. Even though most of them ratified the convention in the late 90s, they were not making their economic zone claims clear. It was the Commission on the Limits of the Continental Shelf, with their procedural rules requiring states to give at least information to the Commission by May of 2009 if they intended to claim an extended continental shelf. This required the states to clarify if they're going to claim beyond 200, they must first clarify where their 200-mile limit is. And this forced, in my observation, the Southeast Asian countries to review whether they were going to make an economic zone claim only from their main territory or archipelagic waters or archipelagic baselines, or whether they were also going to claim from the islands over which they claim sovereignty. This came to a head in May of 2009, in which there was a joint submission made by Malaysia and Vietnam, in which for the first time, Vietnam put out a map in which it showed the extent of its 200-mile claim. Malaysia did the same, and therefore the area of joint is the area between the two claims. They were also kind enough to temporarily show the Philippines where its 200-mile limit was going to be as well, which meant, of course, that neither state was claiming an economic zone or shelf from any of the disputed islands in the Spratlys, which are all located in the area south of the line. They were only claiming their economic zone from their mainland territory, baselines along their mainland territory, or the archipelagic baselines in the case of the Philippines. China, on the same day, which indicates to me they might have had some advance notice, made a formal objection through the Secretary General, in which they said China has indisputable sovereignty over the islands in the South China Sea and the adjacent waters, not a legal term of art, but that could be interpreted to be territorial sea. and enjoys sovereign rights and jurisdiction over the relevant waters, as well as the seabed and subsoil of the relevant waters, bracket, see attached map. And this was the first time that China put its now infamous 9-dash line map before the international community or before the United Nations. With the 4 island groups up here, the Pratas, which is occupied by Taiwan and also claimed by China, Sishao, which is the Paracels, which is also occupied by China but claimed by Vietnam. Macclesfield Bank or Chongsha up here, which actually is underwater by several meters. It's probably not capable of a claim. And then the more complex Nansha, which is the South China, which is the Spratly Islands. So this immediately arose, was China claiming sovereign rights and jurisdiction over all the waters inside the 9-dash line? And that began the debate. This is a map that a couple of colleagues, that's Clive Schofield and all, put out, saying this would be the area of extended shelf. There's now been a separate, this was a separate claim by Vietnam in May 2009. There's now a separate claim by Malaysia in this area here. It was, they overlap a little bit with the Spratly Islands. It's the KIG claim of the Philippines, in which they do not claim maritime zones from the islands. They simply say the islands within this polygon shape are governed by the regime of islands in Article 121. So the question, of course, now is China was claiming sovereign rights and jurisdiction, presumably in all the waters inside the 9-dash line, which also overlaps into the continental shelf and economic zone measured from Indonesia's Natuna Islands. Indonesia doesn't claim any islands that are disputed by others. Their claim to the Natunas are undisputed, but they claim they have continental shelf boundaries with Vietnam and Malaysia. They claim an economic zone beyond that. They haven't yet negotiated treaties with Vietnam and Malaysia, but there's an overlap, of course, between the 9-dash line and their claim as well. Okay, now there was then the institution of proceedings by the Philippines in the, under Annex 7 of UNCLOS, Part 15, on the interpretation of the provisions, in which Philippines basically challenged the legality of the 9-dash line claim, saying that their claims were not exempted by, they're not asking the tribunal to declare sovereignty, decide sovereignty. They're not asking the tribunal to delimit boundaries. They're simply wanting the interpretation of the provisions relating to the legitimacy of claims. And they argued that China has interfered with their sovereign rights. Award on the merits, simply taking the big picture here, it said Scarborough Shoal, which is a bit to the north. In all of the other islands in the Spratly Islands are rocks under Article 121.3. Rocks which cannot sustain human habitation are entitled to a 12-mile territorial sea, but they're not entitled to an economic zone or continental shelf. The tribunal looked not only at the features occupied by China, but all of the largest features in the Spratlys, and the tribunal ruled that no feature in the Spratlys was a full island entitled to an economic zone and continental shelf. They were all rocks entitled to a territorial sea, and some of them were low tide elevations entitled to no maritime zones of their own, including 4 of the features that were occupied by China. So the award on the merits also said that any claim of China to historic rights within the 9-dash line is contrary to UNCLOS and without legal effect, to the extent that exceeds any claims it can make to maritime entitlements under UNCLOS. And the reasoning was, to the extent that China had historic rights, historically fishing rights, those rights were extinguished or given up when it ratified UNCLOS. Award on the merits also suggested, okay, sorry, Michael.
would you be able to finish within a couple of minutes? Because
Couple of minutes, I will.
well, two or
Okay.
three, because
Give me 2 or 3 minutes, I'll be done. The claims
Thanks.
also said that the spratlys could not be enclosed within a system of straight baselines from the 4 island groups which China had claimed. I'll then quickly summarize, and in 2019, December, Malaysia made a separate submission to the Commission on the Limits of the Continental Shelf, and this triggered a whole series of diplomatic notes we call lawfare, in which the Southeast Asian countries continue to challenge China's claims as not legitimate within UNCLOS, and China claims that it seems to be claiming not only rights within the 9-dash line, but also that the 4 island groups are entitled to all maritime zones, including an economic zone and continental shelf. What this raises in terms of disputed maritime areas is going back to Yuri's analysis. Does this mean that there is no disputed maritime areas here because there is a legally binding decision of a tribunal which says the merits of the claims of one of the states surrounding the South China Sea, to the extent that their historic rights or claims from the disputed islands, has no merit and is not consistent with UNCLOS. So this is a slightly different issue that rises from 74 and 83, but I think it's quite important. It also raises the issue with respect to Indonesia, because recently China gave directions to Indonesia to stop exploring for doing exploratory drilling in an area of what Indonesia believes its economic zone. So we have potential disputes with China, with Indonesia, Malaysia, Philippines, and Vietnam. Okay, I'll stop there. Thank you very much.
well, thank you very much. And I'm sorry to have interrupted you, but this is obviously a subject that one could spend a whole day and more talking about. Thank you very much. Very interesting. Robin, could I ask you to take the floor, please? Thank you.
Thank you very much. May I begin by congratulating Yuri on the publication of his book. As I'll explain a little bit later, I think this is going to be the standard work on the subject for a long time to come. I've been asked to talk about the obligations of states in disputed areas of EEZ and continental shelf. This is a large subject, so what I'm going to say will be nothing more than an overview, and I hope we can get that in the allotted time. So please cut me off, Michael, when I'm starting to go over time, as I'm sure you will. Could I have the next slide, please? So I'll begin by asking what a disputed area of the EEZ and continental shelf is. The starting point is where the EEZs or continental shelves of 2 states overlap, and there's no boundary between them, either as a result of an agreement between them or judgment of the court. In that situation, what is called the disputed area, or usually referred to as the disputed area, is the part of the overlap that lies between the boundary line proposed by each state, where each state has in fact proposed a boundary line, or where there is no such proposal, then the part of the overlap that each state could plausibly claim as its EEZ or continental shelf. Next slide, please. This just gives you a couple of examples. The picture on the left is from the recent case decided by the International Court between Somalia and Kenya, and reflects the position before the court's judgment. Kenya claimed that the maritime boundary should be the line of latitude running seawards from the terminus of the land boundary, whereas Somalia That's the red line there, whereas Somalia claimed that the boundary should be the blue line, which is the equidistance line, and therefore the disputed area was the area in between those two lines. The map on the right gives a similar kind of example, although in this case no boundary has yet been agreed or been determined. In the both at sea between the US and Canada, between the north coast of Alaska and the territory of Yukon, where again each state has made a claim which differs. The US arguing the boundary should be the equidistance line, the Canada that it's the line of longitude running north of the boundary. And the disputed area is therefore the area between those two. I should also say that the terminology of disputed areas is not universal. In some cases, people refer to these areas as simply as undelimited areas. It's difficult to put a precise figure on the number of disputed areas worldwide, but the kind of ballpark figure would be around about 150 disputed areas. Next slide, please. I'll start with the obligations of states under the UN Convention on the Law of the Sea. And these obligations are set out in identical terms in Article 74 on the EEZ and Article 83 on the continental shelf. That is to say, they're identical apart from the use of the word EEZ, or exclusive economic zone, in Article 74 on the continental shelf in 83. And there are 4 such obligations. First, to effect a delimitation of overlapping zones by agreement. That's paragraph 1 of each article. Second, to resort to the dispute settlement procedures of UNCLOS if no agreement can be reached, quote, within a reasonable period of time. Paragraph 2. 3, pending any agreement, referred to in Article 1, to make every effort to enter into provisional arrangements of a practical nature. And 4, not to jeopardize or hamper the reaching of a boundary agreement. And that's all. Both those 2 obligations appear not only in paragraph 3, but in the same sentence, which makes them somewhat difficult to disentangle and to precisely analyze. Next slide, please. I think it's fair to say that the 3rd paragraph, which is the one I'm going to concentrate on, dealing with provisional arrangements and obligation of restraint, that this paragraph did not really attract a great deal of attention in the early years following the adoption of UNCLOS in 1982. In fact, it was 25 years before a court first considered this provision, which was in the Guyana-Suriname arbitration. We then had a wait of another 10 years before the next case came along, Ghana against Côte d'Ivoire. Now they seem to be coming thick and fast because the issue was also dealt with in the International Court's judgment last October in Somalia v. Kenya, and the issue arises again in the pending Mauritius and Maldives case before the International Tribunal for the Northern Sea. There was little attention, I think it's also fair to say, paid in the literature, at least the English language literature, which is what I'm familiar with. There was an article in the American Journal by Rainer Lagoni in 1984, which was very widely quoted by people writing about this topic for many years. And his views fed into the reports of the ILA's EEZ committee, which wasn't so surprising as he was the rapporteur of the committee. And then, of course, there was commentary in the Virginia commentary, and the other speaker today, Natalie Klein's article in 2006 on provisional measures and the provisional arrangements. And then that literature really became rather outdated with the decision in Guyana, Suriname. And then the next major development in the literature, in my view, was two articles by the author whom we're honoring today, Yuri, in 2014. First a solo authored paper, and then a paper jointly authored with David Anderson. And in my view, they really set the bar for scholarship to come after that on this topic. And now, of course, we have all this in the book and quite a lot more. And it says something about Yuri's 2014 article that in the Ghana Côte d'Ivoire case, it was quoted in support by both sides. And the article, in fact, was reproduced in an annex to Côte d'Ivoire's counter memorial. On a personal note, can I say that in 2015, I was invited and had the great honor to be a member of a research team set up by the British Institute of International and Comparative Law. And we were asked to research the obligations of states in undelimited areas. That was the terminology used. And in preparing that report, we found those two articles by Yuri immensely helpful, as you'll gather by the frequency with which they're referred to in the footnotes of the report, which was published in 2016. Next slide, please. So I'll start with provisional arrangements. And paragraph 3 of Article 74 and 83 requires parties where there's no agreement, pending any agreement, the states concerned shall make every effort to enter into provisional arrangements of a practical nature. Such arrangements are without prejudice to the final delimitation. According to the arbitral tribunal in the Guyana-Suriname case, the purpose of this provision is to allow some exploitation of the resources of the disputed area to go ahead, even in the absence of a boundary. In the Ghana Côte d'Ivoire case, the Special Chamber of IISTL found that this was an obligation of conduct, so there's no obligation to reach an agreement on provisional measures. But if one party requests the other party to enter into negotiations on a provisional arrangement, the other party must do so in good faith. And refusal to do so would be a breach of Article 74/83. Next slide, please. UNCLOS gives no guidance as to the form of provisional arrangements, and practice varies quite widely. There are some fairly low-key arrangements, such as having a moratorium or an agreement to notify of any possible activities and then consult. But there are more ambitious provisional arrangements. In some cases, states have agreed on a provisional maritime boundary line, which may then become replaced by a permanent line. An example of this is an agreement between Ireland and the UK in 2001 on a provisional continental shelf boundary, which was then replaced by a definitive boundary in 2013, which used, in fact, the provisional boundary agreed in 2001. Even more ambitious are some joint zones for joint development and management. An example on the left is the arrangement between Nigeria and Sao Tome. Unfortunately, the bottom of the PowerPoint has been cut off, so you don't see the full extent of Sao Tome's zone, but it's the darker blue area there, labeled JDZ, which is the joint development area to the south, therefore, of Nigeria's EEZ and to the northwest of Sao Tome's. And on the right here, we have an example of a cooperative arrangement for fisheries pending a boundary between Norway and the then Soviet Union. This lasted from 1978 until 2011, when the Maritime Boundary Agreement came into force. which had been negotiated the previous year. Next slide, please. Now I'll turn to the other obligation in paragraph 3 of Article 74 and 83, which is the obligation not to jeopardize or hamper the reaching of a final boundary agreement during the transitional period, which is the period between the time that a dispute arises and the boundary being determined by agreement or by a court. And this has been considered in 3 cases now in Guyana, Suriname, Ghana, Cote d'Ivoire, and Somalia, Kenya, in the context of petroleum activities. And I emphasize that because what is said in these cases does not necessarily apply to, say, fisheries or marine scientific research. And we don't have any uniformity of approach in these 3 cases. In Guyana, Suriname, the tribunal held that set out in its view what activities would constitute jeopardizing or hampering. Unfortunately, it does so in language which is not altogether consistent, as Yuri has graphically pointed out in one of his articles. But summarized, it is that according to the tribunal, activities that cause permanent physical change or damage to the marine environment, or that might affect the other party's rights in a permanent manner, they will jeopardize or hamper the reaching of an agreement. And on the facts in that case, the tribunal found that drilling for hydrocarbons in a disputed area was a breach of the obligation not to jeopardize or hamper, but that seismic testing was not. Even the conclusion on seismic testing has been subject to some disagreement. In Yuri's book, he points out that there are circumstances where seismic testing may affect the marine environment. In the Somalia-Kenya case, the International Court was asked the same sort of question and took broadly the same approach as the tribunal in Guyana and Suriname. However, next slide, please. Could I have the next slide, thanks? The Special Chamber of the IISTL in Ghana, Cote d'Ivoire, took a very different view and held that Ghana's drilling in the disputed area was not a breach of the obligation to jeopardize or hamper for 2 reasons. First, it had suspended drilling following the tribunal's order or the Special Chamber's order and provisional measures in 2015. Although the Chamber said it would have been preferable, quote unquote, if Ghana had stopped when first asked to do so. And secondly, it was not a breach because the drilling only took place on what turned out to be Ghana's side of the maritime boundary determined by the Chamber. Judge Pike gives a notable separate opinion in which he criticizes the reasoning of his fellow judges as insufficient and unconvincing, quote unquote. And I find it hard not to agree with Judge Pike. First of all, on the first point, to say that it would have been preferable if Ghana had stopped when first requested seems to me to confuse advice or recommendation with an obligation. If you take a current example to distinguish the 2 things, if you're in a country with measures to control COVID, you may be told that you are required to wear a mask, or you may be told that you are advised to wear a mask in certain circumstances. So if you do not wear a mask in the second situation where you're recommended to do so, it would be preferable if you did. But in the first situation, not only is it preferable, it's actually a breach of the law not to do so. So that's one quarrel I have with this conclusion. The other is that there's an element of retrospectivity about it, because Ghana's actions during the period which is relevant, which is the period before the court gives its judgment, is actually determined by the judgment subsequently given. Next slide, please. There was another argument related to this that came up in the Ghana Côte d'Ivoire case, where Côte d'Ivoire argued that because under international law, states have sovereign rights over their continental shelves, and those sovereign rights are inherent and exclusive, but that required a state to refrain from any unilateral economic activity in a disputed area, since it might violate the sovereign rights of the other state should the disputed area eventually be attributed to that state. However, the special chamber, with the exception of Judge Pike, did not agree. And it said that maritime activities undertaken by a state in an area of continental shelf, which has been attributed to another state by an international judgment, cannot be considered to be in violation of the sovereign rights of the latter if those activities were carried out before the judgment was given, and if the area concerned was a subject of claims made in good faith by both states. In other words, if state A drills in an area of continental shelf, which turns out to be on state B's side of the boundary after a boundary has been determined by a court, that will be perfectly acceptable, provided it does so in an area which it claimed in good faith. And the same approach was followed in response to an argument put by Somalia in the Somalia v. Kenya case by the International Court. The court, in fact, in its statement of the law, it consists of a sentence which consists almost entirely of that quotation on the screen there. And I must say, I do have difficulties with this, because if it's taken at face value, it appears to completely undermine the obligation in paragraph 3, not to jeopardize or hamper. It's also rather difficult to jeopardize, to reconcile with the Chamber's own provisional measures order in the same case, where it said that if it ordered Ghana not to engage in new drilling in the disputed area because that might cause irreparable damage to Côte d'Ivoire's rights. And it's also difficult to reconcile with a judgment of the International Court in 2015 in the certain activities case between Costa Rica and Nicaragua, where the court dealt with a somewhat analogous situation in relation to a land boundary. Final slide, please. Or next slide. Yeah. The obligation not to jeopardize or hamper, as I say, is.
Robin, you said final slide or next slide, but can you wrap up within about 2 minutes? That would be helpful.
This is the final slide, subject to a possible map. What has been said in those 3 cases applies only to petroleum activities, and I emphasize that again. And it seems to me that different considerations apply to the obligation not to jeopardize or hamper when you're dealing with fisheries or marine scientific research, and Yuri discusses that particularly in the final chapter of his book. I just throw out another thought as well, and that is that increasingly bodies are calling for states not to explore for any new sources of petroleum. A report published last year by the International Energy Agency said that in graphic terms. So did the UN Secretary General at the launch of the Intergovernmental Panel on Climate Change's latest report. If states eventually do take this to heart, I would like to be an optimist and say when rather than if, but if or when this happens, then that should reduce disputes in disputed areas because they'll no longer be looking for petroleum. One final point is that UNCLOS is not the only provision dealing with restraint. There are obligations of restraint in custom international law, which I cannot go into, that they're discussed in detail in chapter 3 of Yuri's book. And this is particularly important in the Eastern Mediterranean. If the UNCLOS provisions do not represent custom international law, about which there is some doubt. As I say, this is particularly important in the Eastern Mediterranean, where half of the coastal states, that is Israel, Libya, Syria, and Turkey, are not parties to UNCLOS, and nearly all the states concerned have overlapping claims, which are further complicated by disputes over the territorial status of Northern Cyprus and Palestine. Thank you, and thank you for giving me the extra 2 minutes.
Thank you very much, Robin. And now it's over to Natalie. Thank you, Natalie, for speaking to us on your summer holidays and so late at night. Over to you.
Thanks very much, Michael. I'm just going to share my screen as well, I hope.
Yes, that's working.
Okay, let me put it on slideshow. Right, okay. Well, let me join with the other panelists in congratulating Yuri on the publication of this book, which I very much enjoyed reading during the summer holidays here. And I'm very happy to have the opportunity to be able to come and discuss some of the issues. The point that I thought I might zero in on for our discussion this evening in my time related to a fairly small part of the book in some respects, but it feeds into, I think, some bigger issues that I've been interested in looking at and thought it might be worth raising for consideration. And that relates to some of the responses that emerge from the unilateral acts that are occurring in undelimited maritime areas. So I'll just talk briefly about the legal responses that Yuri identifies and also the state practice that he sets out quite carefully in the book, and then turn to a consideration of how the responses are dealt with more broadly in the law of the sea, bring that back to how that ties into undelimited maritime areas, and finally consider some of the difficult questions of threshold that are relevant in the specific context of Yuri's book, and also, I think, more broadly for the law of the sea. Now, in terms of our responses to unilateral acts, the factual setting you've already heard about in terms of Bob's presentation about the South China Sea being an obvious example. Robert just mentioned the Eastern Mediterranean. We know what we're dealing with in that regard. Also, in terms of the legal setting for unilateral acts, Yuri provides a definition of what he's talking about in relation to unilateral acts, thinking about not only the rights of particular states, but also the obligations that they perform. And also when we're thinking about the legal setting, of course, we've got the key provisions from UNCLOS that have already been discussed, and the all critical paragraph 3 setting out the obligations to make every effort to enter into provisional arrangements, and also not to jeopardize or hamper reaching a final agreement as well. So that's kind of the framework that we're dealing with. So when we're thinking about what it is that states actually do in this situation. So from a legal perspective, obviously, when there are activities that happen in an undelimited maritime area, that protests are going to be one of the initial responses. And protests are important from a legal perspective because they prevent any type of argument that there is acquiescence in a specific maritime boundary, and then more broadly, they prevent the formation of customary international law. And we do often see it seems, arguments in maritime boundary disputes that there are boundaries that have emerged based on the practice of parties. So protests are quite important in that regard. And also, of course, they have a political role. But we see also at sea that protests are not limited really just to the exchange of note verbal in a more traditional setting or tweets in a more modern setting, but also physical actions are taken, and that's when we can start thinking about retortion, which is where there are reactions of a state to the actions of another, where the reaction does not interfere with the rights of the target state under international law. So the types of activities that we see in this instance are sort of visible shows of force, or perhaps the escort of vessels. Yuri also explains that among the different legal responses, of course, we might have a situation of countermeasures. And there we are dealing with the law of state responsibility, because we're talking about a possible circumstance, including wrongfulness, where a state will undertake what would be an illegal, otherwise be an illegal act to respond to what the state considers an unlawful act, so as to induce the latter state to stop its illegal conduct. But of course, there's initial difficulties there in trying to determine whether the action that was taken by a state in that undelimited maritime area, was it actually unlawful, or was it something the state could lawfully do? And so that pulls in the discussion that we've just been hearing from Robin about what does fall within the bounds of permissible activity under Article 74.3 and 83.3. And also, when we start talking about countermeasures, there's a range of different conditions that need to be met for them to be lawful. And also in terms of responses, we see that the coastal states often undertake law enforcement measures, and Yuri notes how for that to be a legitimate or lawful response, then it must be government vessels that are involved in those activities. And he also notes that it's conduct against which the claimant state wants to exercise law enforcement. Law enforcement jurisdiction must be one over which it has specific authority. So in addition to this legal frame, then in chapter 8, Yuri goes through in some detail and talks about what has actually happened between states. And there we see in the practice that, yes, protests are really a key response that occurs in this particular setting. And I thought, interestingly, that there were also denials from states as well that they had undertaken the activity that was being protested. We also see that in the practice of states that there are competing issuance of licenses, there's competing national legislation. It seems to happen on a bit of a tit-for-tat basis on occasions. Yuri also recounts how there have been situations where naval vessels are deployed. So this starts going back to examples of retortion that I mentioned. He recounts examples of standoffs, and where also naval forces have maintained a presence when a coastal state is trying to exercise rights in an undelimited maritime area. But then there are also instances, and primarily Yuri refers to the example between Israel and Lebanon, where there is an actual threat of the use of force, or at least a strongly implicit threat of the use of force in the communications between states. Also, we see in the example between Greece and Turkey resort to the Security Council as a way of trying to respond to concerns about actions that have happened in an undelimited area, and of course resort in the Greece and Turkey example to the ICJ. But we've also seen that also other delimitation disputes have, of course, ended up before international courts and tribunals for resolution. Thinking about the Canada-US example, where that resulted in the Gulf of Maine delimitation, in the Bay of Bengal cases, of course, and also the Trinidad and Tobago and Barbados example ended up before a tribunal. Those examples from state practice primarily relate to the petroleum exploitation, and we didn't see in the Chapter 8 discussion situations so much where there was an arrest or eviction of the vessels concerned. But that is something that happens far more frequently in the context of fishing vessels, where there are arrests and evictions of those in practice. So each time that we're looking at what has happened in practice, I think it's helpful to tie that back to the different legal frames that come up in this respect, to try and understand, well, what is it that states are doing in asserting their rights and responding to what they perceive to be as violations of their rights. Now, while the primary interest in the book is in these activities that are leading up to the finalisation of the maritime boundary between neighbouring states, what I think is also quite interesting is just having a look at UNCLOS and seeing that there are actually many different examples within the treaty where there was an anticipation by the drafters that the terms of the convention would be violated and that it would be necessary to define what response would be allowed in that particular situation. So perhaps one most obvious example in this regard relates to the territorial sea and the right of innocent passage. So the convention sets out that there is a right of innocent passage. It describes in Article 19 what counts as innocent passage. And then we have the provision which goes, well, you know, if there is a violation of the right of innocent passage, then under Article 25, you know, the coastal state could take necessary steps to prevent passage that is not innocent. And the coastal state also has criminal and civil jurisdiction over vessels in the territorial sea and to manage violations within the territorial sea. So there are other responses that are built into UNCLOS for potential violations. So, for example, in relation to flagging under Article 92, if a vessel is flagged more than one state, the response is that you don't have to necessarily recognise the nationality of that particular vessel. With marine casualties, the response anticipated there is that there'll be an inquiry. If there is a collision in this situation, the response that's set out is for the response that you're not allowed to do, which relates to disciplinary proceedings by the non-flagged state of the vessel of concern. And also another example in relation to marine scientific research in the exclusive economic zone. We know from Article 253 that if the coastal state has specific concerns in relation to that provision about marine scientific research projects, then the response that is allowed is to suspend or demand the cessation of those particular research projects. Now, obviously, in addition to all of that, where we have prescriptive jurisdiction, and perhaps less surprisingly, in terms of types of responses, law enforcement is, of course, a key dimension in this respect. So obviously there's fisheries law enforcement is allowed in the EEZ under Article 73. Also a lot of provisions relating to powers to enforce pollution laws. We also see the right of visit and right of hot pursuit, which are all set out as responses to unlawful conduct at sea. And while I think in some respects these are responses to activities that are perhaps undertaken by private actors, we also need to consider in that vein that there are requirements on the flag state to ensure that, and so that's due diligence obligations, to ensure that vessels are adhering to particular requirements that might have been set out by the coastal state, for example, in relation to fishery requirements. So also amongst the responses, I thought that tied in somewhat to the various rules of customary international law, which are also set out in the book, and Robin mentions too. So some of those general rules of international law that also are relevant for our responses include rules relating to good faith and abuse of rights, the obligation of restraint, the obligation to peacefully settle disputes, of course, and to not aggravate a dispute. So given that we have a number of different provisions that set out what are expected or required responses in certain situations, to bring that into the context of maritime boundary delimitations, it's interesting that in this particular context, we get the existence of Article 74.3 and 83.3 setting out these obligations in relation to provisional arrangements and the duty not to jeopardise or hamper. So that obligation in itself kind of creates its own specific responses where states are unable to reach agreement as required under paragraph 1 of those two provisions. I thought it was interesting in Yuri's discussion about this idea of exclusivity of coastal state rights and the suggestion that the exclusivity in some respects is sort of no longer exists for coastal states where there is that competition of rights. And I was finding it interesting to think further on that point in light of Bob's presentation, where you perhaps have an indication that the claims of the two states are perhaps not equal in all circumstances. Now, also thinking about how we understand the responses that come up with the obligations under Articles 74 and 83, I found one of the very strong sort of themes throughout the book was this idea of restraint. And while the circumstances of every boundary differ, you know, that need for states to show restraint in this situation was very strong. And Yuri also underlines in the work the importance of ensuring that any action taken has to align with the idea of making an effort to reach a delimitation of the boundary. And that provides us with, I think, more clarity and a greater indication of what it is that states should be doing in these situations. But I think we still have a range of different or difficult threshold questions, whether we're talking about undelimited maritime areas or potentially more broadly in the law of the sea as well. And amongst some of those difficult themes that we have is making decisions about, well, at what point do we kind of cross the line in the particular actions that are undertaken? So we know that use of force is allowed during law enforcement activities, that it should be reasonable and necessary in the circumstances. And we expect that there is a gradation in the level of force that can be permissibly used to the point that you're firing shots across the bow. So the question then is, at what point does it become a threat of the use of force? Of course, we have the Guyana and Suriname decision on that point, but I think there have been some legitimate questions raised about the characterization of those particular activities and whether it really did cross the threshold of the threat of the use of force. And you mentions the case in this particular decision, but obviously it wasn't the focal point of the book. He doesn't really try and make this, delve into this particular issue about where we draw the line. And even if we have a situation where we don't get to a level of a threat of use of force, are we still talking about a possible abuse of rights? And I think that is one of the important parameters when we're discussing retortion, something that is a lawful act, but is an unfriendly act. But at what point does it go a little bit too far and become an abuse of rights? And perhaps one of the earliest indications we had around abuse of rights came from the Corfu Channel case, where, as I'm sure you would all recall, that the court discussed the passage of the UK vessels through the Corfu Channel and did consider that to be lawful. But Judge Alvarez, in his separate opinion, suggested that even when a state was seeking to exercise rights that had been denied, it should not do so in a way that would abuse those particular rights. And certainly the requirement not to abuse rights is recognised within UNCLOS. It is quite difficult once we start trying to untangle what is required in terms of obligations of due regard that are imposed on states, both in the exclusive economic zone and on the high seas, when we're trying to think about, well, what counts as a threat of the use of force. The ICJ has provided some indication that an unlawful threat of the use of force emerges when the use of force itself would be unlawful, but I'm not sure that always is in the context of the law of the sea. And I think even taking one step further away from all of this, and again thinking more specifically about undelimited maritime areas, it gets tricky to try and think about, well, was that initial act unlawful in its own right, and to what extent does that change the type of response that we are able to then follow through with? So you were probably all expecting me to answer those difficult threshold questions, and I will give the great lawyerly response of, well, it depends. And I think Yuri, to some extent, also takes refuge in the it depends response as well, in trying to give us a greater indication on what's expected under Articles 74.3 and 83.3. And in that respect, there is part of me that goes, well, as lawyers trying to uphold the rule of law, we do really need to try and be a bit more articulate about what those standards should be. And it's incumbent on us to try and say, well, this is what the legal standards are and they should apply. And then they will have more meaning in what are inevitably fairly complex historical and political disputes that have been emerging between states in these areas. And I think we can be very pleased that we've got Yuri's book available to us, which has gone a long way in providing greater clarity and lucidity in this area, and I'm sure will be a very valuable resource. So thank you for the opportunity to read the book and to be able to discuss it here today.
Well, thank you very much, Natalie. Clarity, yes, but there's still a lot of questions, I think, raised by the book, and I hope that we'll ask some of them now. I would encourage participants to add to the questions to the Q&A section. We've got one already. I have a couple that I would like to ask, but I'd first like to ask Yuri if he wants to say anything at this stage before we move to the questions. Don't feel you have to.
I think we can go to the questions.
Okay. Well, let's move on then to the questions. I think there's a question from Mohammed Hussain, which asks, really, I think, to compare grey areas of the kind that have been found in one or two recent decisions, such as the one of the Bay of Bengal cases, with disputed maritime areas. And I think he's asking Robin, but really, if anyone wishes to respond to that, including Yuri, that would be good. I will just add a couple of, well, one question, two questions that puzzle me. One, I think, is another one for Professor Beckman to answer at no notice. And this is what happens where you have an overlap between a contiguous zone and an exclusive economic zone. I asked before about two contiguous zones overlapping, but you may have an island that has a contiguous zone, but if it's in the middle of somebody's exclusive economic zone, what happens to the exclusive economic? What happens to the overlap? And my second question is a kind of threshold question, and I thought Natalie was going to come to it, but she didn't. And that is, what makes a state a claimant state for our purposes? Will any claim do, or does it, as I think the tribunal in the Ghana Cote d'Ivoire case said, it has to be a claim made in good faith? Or Yuri in his book uses a number of different phrases about prima facie claims and all kinds of things. So can anyone become a claimant state just by saying, I claim this? So we've got at least three questions, and I wonder who would like to answer first.
Should I perhaps answer the first question in the Q&A box? I mean,
Please do, yes.
The second one from Mubarak Hussain. Yes, thank you for your question. Perhaps I should explain for the benefit of other members of the audience that a grey area, as that term is used in the Bay of Bengal cases, is a situation where the seabed has a different status to the superjacent waters. So in that case, the result of the boundary determined by the two tribunals, in that case the IISTL and the Arbitral Tribunal, was that the boundary between the continental shelf of Bangladesh on the one hand and Myanmar and India on the other went into an area which was within 200 miles of each of Myanmar and India, and therefore within their EEZs. And it was decided that therefore that this is a grey area. The seabed is part of Bangladesh's continental shelf, but the waters above are part of the EEZ of India and Myanmar. And the dispute there is a different kind, really. The dispute is what happens where one state exercises its activities in a way that interferes with the other. And supposing, for example, that Bangladesh wanted to drill for oil in an area, in this grey area, and which was in India's EEZ, and India wanted to fish in that area, or Indian vessels wanted to fish in that area, and the drilling for oil interfered with their fishing. The tribunal in each case basically says, well, it's up to the states to work it out. And I think, if I remember rightly, the arbitral tribunal in the India-Bangladesh state says it's confident that they'll come to some arrangement which will resolve these kinds of disputes. I'm afraid I don't know enough about what's happened in practice since the two awards to know whether, in fact, there are disputes arising in these grey areas. The other point I would make is that grey areas have sometimes arisen in agreed maritime boundaries, and their states do agree what should happen, so you avoid these kind of disputes. An example would be the agreement between Norway and Russia in the Barents Sea, where there are a couple of grey areas, but the agreement itself says what happens in these areas, which is designed to avoid disputes. I hope that helps.
Thank you very much, Robin. Does anyone else want to reply to either that question or the questions which I put?
Michael, I could take a stab at your question of, I'm not quite clear exactly how you have an overlap between economic zone and contiguous zone. State A could claim in the area between 12 and 24 miles, it's contiguous zone, but it's also its economic zone, which means it has jurisdiction over enforcement of its customs, fiscal, immigration laws under Article 33. It has enforcement of its fishing rights and other economic rights under the EEZ concept. Now that might overlap with another state's economic zone, but I think they're different rights. One is enforcing your economic rights. The other one is enforcing your custom, fiscal, immigration. So I don't see that it would be a big problem, but maybe I misunderstood your question.
Well, perhaps it's not a big problem, but to take an example, not a concrete example, but a theoretical one, perhaps, if you had a 1-to-1 rock, it can have a contiguous zone, but it may be in the middle of somebody's economic zone. There's just the two just coexist, and it's not a problem. Is that your answer?
That's my answer, yes.
Yeah.
In the contiguous zone, if they're hovering for ship-to-ship transfer of oil or smuggling of cigarettes, you can arrest them. But if they're illegally fishing, the state whose economic zone it is could arrest them.
Yes.
So I think they coexist.
Okay, well, thank you. I don't disagree with that. If no one wants to respond to my really difficult question, but perhaps they do, we could move on to some of the questions that are in the Q&A.
Oh, I'm happy to give it a go, Michael, if you
yes,
like.
please do. And maybe you could add something about countermeasures. Did you go into countermeasures?
I did mention countermeasures.
Right. I must have been looking for my notes at the time. Sorry, just answer my question.
Well, I'm not sure that I have a good answer. I was probably more caught up thinking about your question about overlapping contiguous zones in the EEZs, and I actually also wondered if does it matter if the state claims one or the other as well in its legislation. They are not necessarily zones that exist ipso facto and ab initio as well, but I otherwise had the same reaction as Bob, that they coexist. But in terms of what makes a claimant state, I was thinking about it. I wondered if the claimant state was really the right terminology, or if we need to think about it in terms of coastal states, because we need to go back to the language of the convention in terms of figuring out what state can make what claims, because you can't have a landlocked state that's going to be claiming a maritime area. Well, they might claim it, I suppose, but there's no legal basis for claiming a particular maritime area. So I would have said you need to pull it back more to a coastal state. And then once you've said, well, you've got your coastal state, then can you go and define your maritime areas that derive from that? So that was my initial reaction to the question there. But and countermeasures you had also drawn. I think one of the difficult things around the countermeasures is actually being certain in the first instance that your act that you're talking about is illegal, to then be able to go, well, because state A has done the illegal act, now state B can claim circumstance precluding wrongfulness to also do an illegal act as well. And then depending on how closely you want to follow the ILC statements around countermeasures, there's a lot of conditions that have to be met for countermeasures to be lawful. So I think that they can be quite, they obviously they are a response that you can have, but I think very difficult to achieve legally in the setting of an undelimited maritime area, and actually more broadly in any event.
Thank you very much. Shall I move on to another question? I don't know, Yuri, do you want to chip in at some point? I'll give you time at the end as well, but
let's see what is work. What do we still have the echo? Yes, I think so much has been discussed, so it's very difficult for me to respond to many of the issues that were raised actually. I think to just pick up on the point that Natalie made about it depends on the circumstances. I think that's very much, I think we do have the echo, right?
well, I can stop it coming out as sound, but carry on. It's probably my fault.
What we'll do is we'll just move to.
Sorry.
Yes, well, perhaps it works better now because we did have the echo. I was just mentioning that so many issues were raised, and it's very difficult for me to respond to all of them. I think the point made by Natalie about it is case specific, that's a very important one. It may not be the most satisfying conclusion. I had the same feeling when I was writing the concluding chapter that this might not be the most satisfying question, but I think it's inevitable. If you talk about what are the rights and obligations of states in disputed maritime areas, that is very much entwined with the specifics of the case. And I think this was also mentioned by Judge Peck in his separate opinion in the Ghana Côte d'Ivoire case, that we can't look for absolutes in this case. For example, are states allowed to conduct unilateral drilling, seismic work? I think ultimately there's going to be a very case-specific answer. And I think this aspect is quite often overlooked when you're discussing disputed maritime areas. Generally, you see quite often that few people fall back on this argument of seismic work, given that in the arbitral awards, the tribunal indicated in Guyana versus Suriname that seismic work is lawful, that this conclusion is generalized to disputed maritime areas generally. And what I try to do by looking at state practice, if you look at state practice, you see a lot of examples to the contrary, where states, when one of them does engage in seismic work, that does create quite significant conflict between them. So I completely concur with Natalie's conclusion. That may not be the most satisfying conclusion, but in a way, I think it's the more inevitable one to reach. And it very much depends on the specifics of the circumstance. I think I will stop here, and then perhaps we can, perhaps one of the panelists wants to reply, and otherwise we can look at the Q&A.
Well, let's move on to the Q&A. There's a question from Olesia Gorbun, which interests me a lot. And this is, if a state makes the reservation under Article 298 to the dispute settlement obligations of UNCLOS as regards maritime or sea boundary delimitation, does that cover paragraph 3 of 74 and 83 or not? Because they're not actually dealing with seabed boundary delimitation as such, as I understand her question. I think it's a very interesting one. I don't know if any of the panel or if you already have an answer to that difficult question.
I can make a comment, Michael. I've thought about this a lot. I think it was a mistake to put paragraph 3 in the same article as paragraph 1 of Article 74 and 83. It should be separate articles. We wouldn't have this problem. In terms of purpose, I would argue that it does not exclude it, but on its face, it's Article 298 allows you to exclude Articles 15, 74 and 83, and paragraph 3 is part of that. And I think there's something in one of the cases that may be the South China Sea arbitration, in which they suggest that paragraph 3 would also be excluded. Now, I may have the case wrong, but I know there's sort of what I would call dicta in one of the cases which mentions this. But I agree with you in principle, it's not about delimitation, and you should be able to go to tribunal if somebody's abused their rights in a transitional stage. But the language of the convention makes this a very difficult problem.
Well,
I think it was the Timor Sea conciliation that you were thinking of, because
okay, yes, it was one of them, I know.
Because Timor was trying to, well, Australia was trying to exclude consideration of paragraph 3 from the conciliation, but the commission said no. Of course, they could consider that.
But
as
I think
well.
the commission didn't have the fact pattern we're thinking of in mind. That's the problem. I think they made a sweeping statement about it not being excluded, rather, and the wise counsel would have qualified that a bit. But you have that language favoring wide interpretation.
Yes, and of course the conciliation wasn't really dealing with the law exclusively. But I think the question draws attention to the words interpretation or application of the articles relating to sea boundary delimitation. So those superfluous words relating to sea boundary delimitation, which weren't needed to describe the articles, might limit the reference to the articles. I think that's the point. But I'm sure that as potential counsel, none of us want to take a position one way or the other on this. We have to
I hope you're right, Michael.
Okay, well, it's a very interesting question. Should we move on to another question? There's so many, I'm afraid we won't get through all of them. But the next question is whether actions, unilateral actions, it says, by third states might have legal effects on the delimitation between the two claimant states. I don't know if anyone wants to answer that. I think I could answer it by saying that it depends on what the actions are, but it would really be the reactions of the claimant states to the third state's actions that might have an effect on the delimitation if they sort of take enforcement action against third states or anything like that. I don't know if that answers the question, or if anyone has another possible answer.
I would have thought that the acts by a third state in themselves can't have any effect.
No.
As you say, the response of the claimant states may be different, may be relevant.
Another very broad question, but I guess we could narrow it down, is from Aditya Roy, and it's whether concepts relating to the delimitation of territory, land territory, how far these apply to the maritime delimitation or maritime disputes, and the example of uti possidetis. But that's a very broad question. I don't know if anyone wants to offer an answer to that. I think it's been studied quite a lot, but
I could just say in relation to the uti possidetis point,
yes,
that was specifically rejected by the International Court in the Nicaragua-Honduras case.
Right.
It's not being relevant at all.
Right. Then we have a question about joint development in disputed areas, and how far joint development, what it means exactly, and what sources help us to understand about joint development. I mean, this is something that the British Institute did a lot of work on a long time ago and have tried to update, I think. I don't know if anyone has any advice on Sevde Nur Julak, who's interested in joint development.
And I think David Ong wrote an excellent piece on it quite a few years ago in the, I think it was in the American Journal of International Law, on whether there was customary international law developing around that. But I wouldn't think that we have reached the stage that we could argue that there was a customary law obligation for joint development that arises from those particular unclosed provisions.
Yeah.
Yeah, it's the most common remedy for, or the most common provisional arrangement of a practical nature for overlapping continental shelf claims or so on, but otherwise legal. We have a book on it, joint development in South China Sea, which has a couple of chapters talking about the general concept. I think David might have written one of those as well.
Right.
But otherwise, it's just one of the most popular provisional arrangements of a practical nature, shall we say, where you're setting aside the sovereignty dispute for a particular time and jointly sharing the resources.
Thank you. Nishan Shetty asks about the extended continental shelf, I think, going out to a maximum of 350 nautical miles. We haven't really talked about the overlaps between the extended continental shelf and other areas. I don't want to get into that myself.
I could just say that, of course, Article 83.3 will apply beyond 200 miles as well as within it, so that would be relevant. The other point is, I think that in practice, states are not actually engaging in much activity at all in the continental shelf beyond 200 miles, even where their submission has been the subject of recommendations from the Commission on the Limits of the Continental Shelf. So I think in theory it could create more maritime disputes. I don't think it has done so to date, but I may be wrong on that. And there is also a provisional arrangement, by the way, applying to the extended continental shelf in the Indian Ocean between Seychelles and one of its neighbors, which has slipped from my mind.
Just one quick point is that the extended continental shelf can go beyond 350 nautical miles. The 350 is one of the criteria for the limit.
Well, we've got 4 or 5 more questions, but I did say we would finish at 2 o'clock, and I think it's only fair to the participants, particularly those for whom it is already past midnight, that we do try to finish more or less on time. So with apologies to those who've asked questions and we didn't get round to them, but we can all read them on the Q&A and they're very interesting. I'd like to conclude by asking Yuri if he would like to say a few words by way of conclusion. Thank you.
Yes, well, thank you very much, Michael, first of all, for being here and sharing the session. I also want to thank the panelists, because when I listen to all of you, I sometimes think, okay, perhaps there needs to be a second volume, which are not really easy to write, to be honest, but there are so many questions that are still open around, for example, how can states respond to acts of unilateralism? I think that is one area on which I do touch, but there are so many unknowns in that regard still, that there's still probably much more work to be done on that. But that being said, like I said, I really appreciate you taking the time to read the book and comment on it and provide further food for thought. Like that, I'm not sure whether it's going to be a monograph, but perhaps there's still various articles in the topic as such. And I do hope that the book does at least help a little bit also in practical terms when it comes to disputed maritime areas and how to deal with them. And I think this was also a point, and I think Natalie mentioned that. And at the very end, about the applicable international law, I think it is present. So it's not so much about there not being development law. I think states are often a bit more creative in interpreting the applicable international laws. They're not always that eager to exercise restraint, but I think ultimately, and that's what I also, or the point I have tried to bring across about paragraph 3 and how to interpret it is to see it in the light of that ultimately states ideally come to the limitation. And in my view, that also means that states, when it comes to their subjective positions about whether an act would be lawful or unlawful, should also be taken into consideration. Because if you have 2 states, one of them would view seismic work as making the delimitation exercise more difficult or more difficult to come up with a final limitation, I think that does suggest that there has been a breach of the applicable international law. Of course, I do see the danger in that position, that it might ultimately lead to one state arguing that nothing is permitted within a disputed maritime area because of it being under its exclusive sovereignty, etc. But I will stop here because I do keep an eye to the time. Once again, Natalie, Robin, and Bob, thank you very much. Michael, my special thanks to you as well for, as you can see, we are in the same room, but because of social distancing, it was not ideal in terms of the different microphones. But anyway, thank you also to the participants for being here. And if there are questions which we have not been able to touch upon in the Q&A, you can always email to me and I can try to give you an answer. So thank you very much.
Well, thank you very much, Yuri, and thank you very much for the book, and thanks to CUP for publishing the book. Unless anybody else wants to say something desperately important at this stage, I think we could conclude the meeting and allow Natalie to go back to her holiday. I'm sure the evening's only just beginning wherever you are.
Yes, well, I've probably had enough caffeine and sugar this evening. I could go out dancing now, but
unfortunately,
we'll
we can't join you.
There's not much of that happening here at the moment, I must admit.
Okay, well, thank you very much to all the participants, the speakers, but all those who have joined online for what was, I think, a very pleasant, a very good event. And thank you very much again to Yuri for the excellent book. Thank you.